Device, text, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney as an attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
Oh, here we go.
We're a little confused, and I don't mean to interrupt the proceeding, but as we're watching...
Can you state your name for the record, please?
I'm sorry. Alan Jackson on behalf
Oh, here we
of...
go.
We didn't see which case number was called. Which case number... Of course, I'm sorry. Alan Jackson on behalf of... We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said yes. The Rule 17 that Mr. Brennan's dealing with.
Look at me. No. Come here. Look at me. Hey.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So case number, I just want to make sure, procedurally,
Look at me. You're looking.
Mr. Kearney, the case number that was called Commonwealth versus Kearney.
00117.
Okay.
That's correct.
And she needed to be here, and she has right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward.
Pressing things.
Oh!
I don't know that that's... Yes, it is her case, but what's going to challenge a Rule 17 request related to documents in her case?
Specifically pertains to the prosecutor asking for information in her case to move forward her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues.
Ashley, don't look at him. Look at me. Ashley! Look at me. I don't wait.
Look at me. You're looking.
But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth has been Rule 17 for 2 years on this case. Over and over again, Your Honor. The Commonwealth has taken positions on Rule 17. We've taken positions on Rule 17.
One, two, three. Peekaboo! Ready?
Whatever.
Peekaboo!
I'm only asking that be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral arguments as it attends to, and we're prepared.
And did you give the court notice of that?
We did to Justice Kennedy.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues Mr. Brennan bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration of the court such that that causes any issue for any of the parties?
No, absolutely not, Your Honor.
Yeah. Look at me. You're looking. Oh, here we go.
Before the court makes its ultimate ruling, once Mr.
For fuck's sake, Ashley, don't look at him. Look at me. Ashley! Look at me.
I'll consider the request.
Okay.
Judge, I have no objection procedurally to counsel on
Yeah. Look at me.
that's an issue.
You're looking.
You want to? No. Hey, come here. Look at me. Hey, look at me. What did I say?
Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, A.D. Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her considerations there, too.
Appreciate the accommodations.
So, A.D.A. Brennan, with the court's apologies for the interruptions,
Say cheese.
the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swapped.
An understanding.
What's up, baby?
What the parties make.
Say cheese. Spin it up, purple Mercedes. Fall in love.
Oh, here we go.